Welcome to this short introduction on diversity in higher education. This video will provide you with an overview on the changing nature of the U.S. population and its effects on higher education. We will briefly look at demographic information, the charges set forth by federal and state legislators, the legal landscape that institutions of higher education must navigate, different types of minorities serving institutions, and the things you may encounter while working in one. Let us first examine the changing landscapes of the U.S. and California population. So in this first slide shown on your screen is a racial demography of the United States in between the years of 2000 and 2020. This information comes from the U.S. Census Bureau. And one of the prevalent trends you will see all the way from 2000 is that there's a steady decline in the proportion of white or European Americans in the U.S. population. Over the past 20 years, we see that it's almost a 10% decrease in the population. Now, if we look at what we would consider minorities in the United States, that would be American Indian or Alaska Native, Asian and Pacific Islanders, Black or African American, and Hispanic and Latino, we will see that there's a general trend to be increasing, especially with Hispanic and Latino and our Asian and Pacific Islander group. So if we look in 2000, Hispanic and Latinos composed of 12.6% of our population, but 20 years later in 2020, they now compose of 18.6% of the population. If we were to look at the California context, again, we will see that there's a general decline in the proportion of European Americans or white Americans in our population. So in 2000, they composed of 47.2% of the population. In 2020, it is down to 35.9%. If we look at Hispanic, Latinos, and Chicanos, we will see from 2000, they compose 32.5% of the population, and currently, or in 2020, they're 39.5% of the population. So as a matter of fact, in California, individuals who identify as Hispanic and Latino outnumber those who identify as white or European American. Again, we also see a general increase with Asian and Pacific Islanders from 11.4% of the population to 15.6% of the population. Whereas African Americans composed about 6%, so somewhere between 6.5% in 2000 to 5.6% in 2020. And then we also have Native Americans at about 0.5% of the California population. So one of the things to take away from this is that in the US context, the percentage of minorities, especially Hispanic, Latinos, and Asian and Pacific Islanders, are steadily increasing. In the California context, the percentage of minorities, especially Hispanic and Latinos and Asian and Pacific Islanders, are also steadily increasing. The percentage of African Americans is trending downward slowly, but overall, if you were to combine all the minority groups, that is Asian and Pacific Islanders, Hispanic and Latinos, African Americans, and Native Americans, you will see that there is an overall upward trend for minorities. Those who identify as Hispanic and Latino outnumber white individuals in California. The information we have just seen as regards to our demography is important on a number of different levels. One way it's really important is that it affects the future of our economy. So for example, as the Public Policy Institute of California points out, California's higher education system is a critical driver of the state economic progress. As the state's economy and demography continues to change, there are questions as to whether its workforce will be ready for the jobs of tomorrow. So let us first take a look at a figure that is included in the report. And this figure basically projects the needs and supplies of the workforce in 2030. The PPIC report presents projections of California's workforce skills through 2030, focusing on the supply and demands for workers with a bachelor's degree or higher. They project that 38% of all jobs will depend on workers with at least a bachelor's degree, but only 33% of workers will have one in 2030. Their findings indicate that the state will fall about 1.1 million college graduates short of economic demand if our current trends persist. And they've labeled this as a problem called the workforce skills gap. In a similar line, there is a national call to broaden participation, especially in the STEM workforce. So this is not only a California issue, this is a national concern. And in order for the United States to maintain the global leadership and competitiveness in science and technology, which are critical to achieving national goals, the U.S. must invest in research, encourage innovation, and grow a strong, talented science and technology workforce. In 2007, the Institute of Medicine issued a report titled Rising Above the Gathering Storm that addresses the challenges facing the U.S. competitiveness in science and technology. They made a number of recommendations to strengthen research opportunities and science and technology education, that is, K through 12, undergraduate, and graduate. The report acknowledges that a comprehensive and coordinated federal effort is urgently needed to bolster U.S. competitiveness and its preeminence in these areas. The congressionally requested report makes 4 recommendations along with 20 implementation actions that federal policymakers should take to create high-quality jobs and focus new science and technology efforts on meeting the nation's need, especially in the area of clean and affordable energy. So the 4 large recommendations are: increase America's talent pool by vastly improving K through 12 mathematics and science education, sustain and strengthen the nation's commitment to long-term basic research, develop and recruit and retain top students, scientists, and engineers from both the U.S. and abroad, and ensure that the United States is the premier place in the world for innovation. Now, some of these actions will involve changing existing laws, while others require financial support that would come from reallocating existing budgets or even increasing them. In 2011, the Institute issued a further report acknowledging the changing American demography and the need to broaden the participation of members from underrepresented communities to address the challenges that the report, Rising Above Gathering Storms, had previously highlighted. The follow-up report, called Expanding Underrepresented Minority Participation, recognizes that although minorities are the fastest growing segment of the population, they are underrepresented in the fields of science and engineering. Historically, there has been a strong connection between increasing educational attainment in the United States and the growth in and global leadership of the economy. The cultivation of diverse and inclusive STEM faculty at research universities was proposed as a mechanism for enhancing participation at all levels of science, technology, engineering, and mathematics education. How is this intersection of the changing national or state demography and the need for increasing minority participation in higher education is playing out in colleges and universities? Since I have data from my campus readily available, let us take a look at the demographics of UC Santa Barbara undergraduates from the years 2000 to 2020. So in this slide, you could see I have sort of 5 different points in time: 2000, 2005, 2010, 15, and 20. And the blue bar indicates individuals who identify as European American or white. And in 2000, 63% of our undergraduate population identified as white, whereas in 2020, only 35% of our undergraduate population identifies as white. So this is kind of in matching with the general decrease that we have seen in the state population and also in the national population. If we were to look at the yellow bar, which is our underrepresented minorities, and I'm being very specific here in this definition, underrepresented means African Americans, Native Americans and Alaska natives, and then also Chicano, and Latino. And the reason why we're saying underrepresented is because historically, these individuals have been historically underrepresented in higher education. So if we were to look at these three minority groups and just kind of group it as one called URMs, we see that in the year 2000, they composed of 19% of our undergraduate population at UC Santa Barbara. However, in 2020, they composed more than a third, so 34% of the population. Now, if we were to also include Asian and Pacific Islanders with our underrepresented minorities, then we have this broader category of individuals in the United States just called minorities. And if we look at the Asian and Pacific Islanders, they've also increased in our campus population. So from 2000, they composed of 16% of our undergraduates, but in 2020, they composed of 29% of our undergraduates. So let us look at the legal landscape affecting higher education. Let's start with 1954, which is Brown versus the Board of Education of Topeka. So Homer Plessy challenged an 1890 Louisiana law that required separate trains for Black Americans and white Americans. The Supreme Court held that separate but equal facilities for white and Black railroad passengers did not violate the Equal Protection Clause of the 14th Amendment. And this is going to be an important thing to remember, that you will hear the 14th Amendment or the Equal Protection Clause of the 14th Amendment referenced in many of these cases. Back in 1954, the Supreme Court basically overturned Plessy, and they ruled that racial segregation of public schools was unconstitutional. The case was one of the cornerstones of the civil rights movement and helped establish this precedent that separate but equal education and other services were, in fact, not at all equal. In 1978, we have Regents of the University of California versus Bakey. In this case, Bakey was a European-American student who applied to medical school at UC Davis. Although his admission scores were well above that of the average admittee, and the school had openings for when he applied, his application was rejected because of the school's racial quota system. Previously, the school had implemented a quota system where white applicants could only compete for 84 out of 100 spots, and the remaining 16 were reserved for racial minorities. The court had ruled that the university's admissions criteria, which was used as a definite and exclusive basis for an admission decision, violated the Equal Protection Clause of the 14th Amendment. Therefore, what was decided from this case is that, yes, race may be one of the numbers of factors considered in admission, but special admission programs, that is, quotas, were not legal. Following that, in 1982, we have Plyer versus Doe. Now, in 1975, there was a revision to Texas education laws that allowed the state to withhold from local school districts state funding for educating children of illegal aliens. Now, this case, Plyer versus Doe, focused on whether this Texas law violated the Equal Protection Clause of the 14th Amendment, which is that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And the court had reasoned that illegal aliens and their children, although not citizens of the United States or Texas, are people in the ordinary sense of the term, and therefore are afforded 14th Amendment protection. Since the state law severely disadvantaged the children of legal aliens by denying them right to an education, and because Texas could not prove that the regulation was needed to serve as a compelling state of interest, the court basically struck down that 1975 law. In 1996, we have Hopwood versus Texas. And Hopwood versus Texas involved 4 white applicants who were rejected from the University of Texas Law School. They challenged the school's admissions policy on the equal protection ground. For the purposes of affirmative action, the policy had included race as a factor. In 1996, this decision basically barred racial preferences in admissions in the Fifth Circuit, which includes Texas, Louisiana, and Mississippi, and ended all consideration of race in admissions at UT Law. Now, this ruling will later be overturned, as we will see. However, in response to Hopwood versus Texas, the Texas legislators basically developed this top 10% law, or which is known as the Texas House Bill 588. And this state law was passed in 1997, so the year after Hopwood versus Texas, that guarantees Texas students who graduated in the top 10% of their high school class automatically were admitted to all state-funded universities. Now, also in 1996, in the state of California, we had the passing of Proposition 209. Now, Proposition 209 added Section 31 to the California's Constitution Declaration of Rights, which said that the state cannot discriminate against or grant preferential treatment on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, and public contracting. Proposition 209 banned the use of affirmative action involving race-based or sex-based preferences in California. With that being said, people who do the sort of work that I do, which is diversity in higher education, especially in the state of California, we find ways of interpreting and understanding the law and develop policies and procedures that do not violate Proposition 209. And so there's got to be an understanding of what things will be affected by the proposition itself. So at the University of California, we usually pass out guidelines to individuals that this may affect. So some of the things that we take into consideration is that the university may, as part of a comprehensive program of outreach, we may target or increase special efforts within that program to reach a particular group of where the program's benefits are available broadly to all other groups. And the special efforts are necessary to reach targeted groups members effectively, and therefore to level the informational playing field. So in recruiting of, say, for example, new undergraduate students, because we provide recruitment efforts to all potential students of the University of California, our university can focus, a subset of that specifically for, say, like the Latino communities in the Central Coast. And we can even put additional efforts to do it. But the fact is that we still have to provide outreach support to all segments of California. The university may choose to advance its educational goals, including diversity and equal opportunity, by introducing or placing additional weight on a broad range of selection criteria when making admissions and employment decisions. So, for example, holistic review in admissions considers factors such as income level, first-generation status, neighborhood or community circumstances, disadvantages that a person needed to overcome, low-performing secondary school attendance, and the impact of an applicant's background and experiences on their academic achievement. Also, Proposition 209 does not apply to private, non-university organizations which may provide scholarships and other educational benefits targeted to women and underrepresented minorities. And also, a very small group of individuals may receive funding that deals with diversity. And so if there's a university program that apply or to receive these federal fundings and must use race or gender-based criteria to become or remain eligible for the federal funding program, those programs are exempt from Proposition 209. Moving forward, in 2003, we have Grudder versus Bollinger. And in 1997, Barbara Grudder was a white resident of Michigan who applied to admission at the University of Michigan's law school. Grudder applied with a 3.8 undergraduate GPA and an LSAT score of 161. She was denied admission, and the law school admits that it uses race as a factor in making admissions decisions because it serves as a compelling interest in achieving diversity amongst its students. The court held that the Equal Protection Clause does not prohibit the law school's narrowly tailored use of race in admissions decision to further a compelling interest in obtaining the educational benefit that flows from a diverse student body. The court reasoned that because the law school conducts highly individualized reviews of applications, that no acceptance or rejection is based automatically on a variable such as race, and that its process ensures that all factors may contribute to diversity are meaningfully considered alongside race. So therefore, holistic approach to admission has been viewed to be legal. In 2003, we have Gratz versus Bollinger. Again, this is involving University of Michigan and their admissions. And in 1995, Jennifer Gratz applied for admission at the University of Michigan's College of Literature, Science, and Art, was a resident of the state of Michigan. However, Jennifer Gratz was denied admission and told that although she was qualified, she was not competitive enough of an applicant to be admitted. Now, the University of Michigan's Office of Undergraduate Admissions considered a number of factors in its evaluative process, such as high school grades, standardized test scores, curriculum strength, alumni relations, geography, and leadership. But the Office of Undergraduate Admissions also considered race and admits virtually every qualified applicant from certain groups determined to be underrepresented minorities. Now, the question is, did the University of Michigan use of racial preferences in the undergraduate admissions violate the Equal Protection Clause of the 14th Amendment? The court held that the admission policies were not sufficiently it was not narrowly tailored to meet strict scrutiny standards. Because this policy didn't provide individual consideration, but rather resulted in the admission of nearly every applicant from a underrepresented minority group, it was not narrowly tailored in a manner that was required by previous jurisprudence on this issue. Now in 2013, we have Fisher versus the University of Texas. And in 1997, the Texas legislature enacted the law requiring University of Texas to admit all high school seniors who ranked in the top 10% of their high school classes. So this was mentioned a little bit earlier. After finding differences between the racial and ethnic makeup group of the university's undergraduate population and then the state population, the University of Texas decided to modify its race-neutral admissions policy. Their new policy would be to continue to admit all in-state students who graduated in the top 10% of their high school classes. For the remainder of the in-state students who were applying, the university would consider race as a factor of admission. And so in this case here, Fisher, a European American woman, applied for undergraduate admission at UT in 2008. Fisher was not in the top 10% of her class, so she had to compete for admission with all the non-top 10% in-state applicants. And therefore, race was taken as a factor, as a potential factor in admissions. Now, was this a violation of the Equal Protection Clause of the 14th Amendment? It was ruled as yes, but this is only a legal technicality here, in the sense that the lower courts that allowed University of Texas to go through with this plan, they didn't sufficiently apply a strict scrutiny to the university's admissions policy. That is, that the lower courts did not scrutinize whether the admissions policies were precisely tailored to serve a compelling government interest. So this case was then later relitigated, but this time focusing on whether this violated the 14th Amendment. because in reality, the first case didn't really answer that particular question. It was just overruled because of a legal technicality. The court found that the University of Texas use of race as a factor in the holistic review used to fill the spots remaining after those top 10% plan was narrowly tailored to serve a compelling state interest. Therefore, the court decided that the University of Texas use of race as a consideration in the admissions process did not violate the Equal Protection Clause of the 14th Amendment. Now, in 2018, we have the Trump administration, which reversed a lot of Obama-era guidance on the use of race in admissions. And one of the things that we have seen was that there was a lawsuit filed it was Students for Fair Admissions versus Harvard University. The lawsuit is concerned with discrimination against Asian Americans and the affirmative action program at Harvard University's student admissions process. In October of 2019, U.S. District Court Judge Allison Burroughs of the District of Massachusetts had rejected the plaintiff's claim, ruling that Harvard's admission practices meets constitutional requirements and does not unduly discriminate against Asian Americans. However, in January of 2022, the Supreme Court had agreed to hear this case and is consolidating it with a similar case related to admissions practices at the University of North Carolina. Now, how is it that educators typically argue in support for diversity in higher education? And you will hear lots of really important, points to, talking points. And so one would be diversity broadens perspectives. It introduces ideas from many, individuals in different segments of our community, and it forces us to think of things in multiple ways and to approach problems from multiple directions. It supports an inclusive vision of who we are as people. It increases innovation because then you have the sort of multifaceted approach to answering questions. It helps us to meet the needs of global society and a diverse marketplace. Also, you'll hear things like it reduces harm of racial isolation and segregation. So it's being inclusive in the process of higher education. Now, for when we do meet in person, we will have discussions, and I want you to consider a couple of things. So, for example, what do you make of the history of race and admissions? How has thinking about the value of diversity influenced, the legal thinking that we had seen? During our in-person discussions, we will brainstorm and discuss other reasons why educators, business leaders, military leadership all have spoken out about the importance of diversity in higher education. We will also, discuss how do we address things like implicit bias in the admissions process, which also affects things like hiring, getting your articles written up for journals, or even receiving grants from a granting agency. So how do we address implicit bias in these different areas? One question that I, often have to consider is how is it that the university, has to address the issues of funding for individuals who are DACA or Dreamers, or individuals with AB 540 status in the state of California. The next segment, we'll talk about minority serving institutions. So what is a minority serving institution? Well, firstly, it's an institution of higher education, and its definition is primarily based on population of the students that attend that institution. Typically, there's a threshold of 25% minimum of enrolled domestic. Now, notice, domestic students, you have to put aside the international students. So put aside international students and just look at those with U.S. citizenship. So 25% of those domestic students must belong to a specific ethnic minority group. And if the institution does have that demographic, then it is eligible to apply for federal funding to support different types of educational and academic programs. So funding and grants are part of the Minority Serving Institute designation. Now, there are a number of different types of minority serving institutes in the United States, and their origins, again, sort of differs in the historic sort of context. But here's a few different types of MSIs that you may have heard of. So we have HBCUs, or which are historically Black colleges and universities. And those are unique because it's a set number of universities and colleges. There are about 100 of them in the United States. This list will never ever grow because they were established based on the 1964 Civil Rights Acts. So they have a very specific definition of what are HBCUs. However, you can have a predominantly Black college or university, and these are non-HBCUs, so they happened after 1964, but a significant proportion of their universities, so more than 25%, are Black or African Americans. Then we have Hispanic serving institutions. All four of our campuses, UC Santa Barbara, UC Merced, CSU Channel Islands, and CSU Fresno, we're all Hispanic serving institutions, which means that at least 25% of our undergraduate populations identify as Hispanic, Chicano, Latino. And then we also have Asian American and Native American Pacific Islander serving institutions, or ANAPISIs, and tribal colleges and universities, or TCUs. Now, some of these had emerged from historical inequality. So, for example, Black colleges and universities, or tribal colleges and universities. And so they do have an origin that goes before 1964. And so that's the historic context for those two types of institutions. Another characteristic of all of these minority serving institutes is that they usually serve minority groups that had a lack of access to higher education. Some of the newer MSIs, minority serving institutes, came about because of changes in demography. So as we're seeing the increase of minorities in the US population, or even in California's population, then we end up with things like Hispanic serving institutions. But all in general, all MSIs serve some type of minority community. And the question is, what does it really mean to serve a minority community? Well, that means that everyone is a learner, not only in the institute itself, but then in the community that supports that institution. It's the institution's job to remove all sorts of barriers, which may include socioeconomic barriers or epistemological barriers. Another characteristic of minority-serving institutions are the teachers. So instructors are not the only individuals who teach at minority-serving institutes. Students, mentors, peers, community leaders, and other experts may participate in the teaching process. And these individuals may cover aspects of a course content, or study skills, or time management skills, or social and cultural issues. And so as a few examples that I'm familiar with at my university, we have things like the Ondas Center, which is when our university became a Hispanic Serving Institute in 2014. We received funding to establish the Ondas Center, which basically promotes the success and retention of first-generation college students with an emphasis on the first-year transition and underrepresented student experiences on our campus. Another sort of center that we have at UC Santa Barbara is the Transfer Student Center to help students who transfer from community colleges into the UC. We also have the Educational Opportunity Program, which is committed to providing a support that validates each student's experience and nurtures a sense of participation, belonging, and empowerment. The EOP also provides mentorship, academic programs, one-to-one counseling and advising, campus student support services, referrals, and social and cultural programming. And they strive to maximize students' involvement and success in the campus academic community. There's also a group that helps with tutoring students and sort of helping them with their academic skills. This is our campus learning assistance services. And so, like I say, they help students increase their mastery of course materials through group instruction, one-on-one tutoring, and also academic skill development. And then at UC Santa Barbara, we also have a program called the Promise Scholars, which empowers high-achieving first-generation students from low-income households. And the Promise Scholars offers grants and scholarships to entering first-year students at UC Santa Barbara. The grant covers them for all 4 years of their undergraduate education. Or for transfer students, it'll cover 2 years of their education. Now, your campus may have very similar programs and they may go by different names, but that is really a unique thing about minority serving institutions, is that you will see lots of resources developed for many different segments of our student population. Another thing you will see that makes MSI, working at an MSI really unique is how one teaches at an MSI. So while teaching at an MSI, you basically engage a lot of students in culturally relevant research and problem solving. And that is basically, you want to engage students in the opportunity to inquire into issues that they may have, experience with, or that they view to be relevant and immediate to them. So it's really working from the knowledge base of the student and the lived experience of the students. You will see different types of pedagogical strategies. Some of these we'll discuss throughout the Institute. Some of these you will actually see in practice while you're shadowing your mentors at CSU. So you'll see different types of pedagogical strategies such as problem-based learning or active learning, team-based learning, community-based types of learning. You will see definitely content-related issues such as relevant illustrations, relevant issues, very current, material. My takeaway point is that at minority-serving institutions, we make it central. We basically make students a part of the learning process, from conceptualizing problems to generating ideas of problems, to the development of solutions. And this is where I will leave it. This is where I will leave the video, but be prepared to have a lot of the discussions, that I have highlighted earlier. And I look forward to hearing from your perspective of how you see yourself contributing to diversity efforts in higher education. Thank you.